right. Welcome to DTLA's Here Comes a Judge, our next chapter with the Honorable Judge Ashley Wysocki of the 162nd District Court. Judge, thank you so much for being here with us today.
Thank you for having me.
All right, well, I'm going to jump in with the hard-hitting questions like, what do you see the best lawyers doing in your court?
I've thought about this question, and for me, it comes down to three words: preparation, humanism, and professionalism. If you are prepared, you're going to pretty much do well in the courtroom. There really isn't anything that could make you over-prepared for a case. And then humanism, we're all people here, right? The jurors are, the witnesses are, the judges. And so the more you talk on a normal level, I think and that includes, acknowledging faults or mistakes. That really is successful in my courtroom. And then just being professional. And some of us are younger, some of us are older. Sometimes we have emotions that get heated up by virtue of what's gone on for the 2 years that you've been trying this case that the court doesn't know about. But in the courtroom, those things should be left on the side because all it does is interfere with being an effective advocate, in my opinion.
That makes good sense. I know it's interesting. I think a lot of times lawyers' egos seem to get in the way of like the humanism aspect of it. And they think that somehow by being a bully or being, overbearing, that somehow that's going to like make them an effective advocate, which it seems to be the exact opposite.
I think it's the opposite. I think there's a difference between ego and confidence. And I certainly think that you should be confident. You should be confident in your positions. You should be confident in the way that you portray yourself. But there's a difference between that and ego or aggressiveness. And I can see it on jurors' faces when an attorney is overly aggressive or responds to the opposing attorney or the witness in a way that seems disproportionate and unprofessional to them. So those things go hand in hand, the professionalism and the humanism.
Well, kind of tying in with that, what are some of your biggest pet peeves?
I would say one of my biggest pet peeves is not taking responsibility for your actions as an attorney. We all make mistakes. I mean, that is going to happen no matter how long you've been practicing. What I feel like is not effective is coming to the court and being aggressively defensive in light of mistakes. For me, it makes more sense if you've made a mistake as an attorney to say, Judge, I made a mistake. I did this wrong, or this is what happened. Please don't hold it against my client. Now, that argument's going to be taken if it's better, if it's your first or, not a repeated habitual conduct that you can't just blame it on yourself and the court just, ignore it. But to me, that is one of the biggest problems I have is dealing with when things go wrong and attorneys are aggressive to the court on things they shouldn't be aggressive about.
Okay, that makes a lot of sense. Well, switching gears just a little bit, hearings. Always one of the things that's most interesting for people, and what are your practices and procedures on getting a hearing in your court?
So for my court, it's pretty simple. You call the clerk and you request a hearing. I do certain hearings by submission, primarily just summary judgments, and then motions for default, motions for substitution of counsel, withdrawal, those type of motions. But everything else, I handle in person unless I have personally granted the request for it to be through Zoom or another means. I do typically, if one party requests it and it's something that I feel is a reason to have a hearing by Zoom, I do prefer to have everybody appear by Zoom. It's just a little bit easier. Our new AV system does make that more manageable now, but I still would prefer if one's going to be on Zoom that everyone's on Zoom. And then There, it's really simple. I think we have a pretty good, for my court, reasonable time to get hearings. I would say you could help the court out is as soon as you know that a hearing that you have scheduled is not going to go or is going to need to be reset or you're going to settle. If you can let the court know as soon as possible, because as long as you're on the motion docket, then nobody else can take that time. And one of the things I've been struggling with in my decision making is whether or not it's better to have set motion practice times or a docket, because I end up 50% of the time that's set on my hearing docket typically going away the day of or the night before, which gives no one the ability to take that time in the interim. So it should be a pretty simple process for my court. You just go through the clerks.
About how far out is your court at this point?
I would say it's typically at least 2 weeks would be reasonable. If it's something like a summary judgment, that's usually something that's a little bit harder. So I do always advise people, if you've got an order, a scheduling order that requires you to have summary judgments heard at least 30 days before trial, you should not be looking for a setting, 3 weeks before that deadline, because those get filled up pretty quickly. So that should always be something that's on your mind to ensure that you can get that setting, because I do sometimes have people requesting emergency settings because they're in fear of passing their deadlines in their scheduling order. I would say though, just looking, if you check back, if there's something important, if you check back every week, like I said, cases fall off. And sometimes it does happen before the night before. And so if you can fit in, you can fit in.
So in that vein, for you, like how do you proceed with like requests for like emergency hearings? What are your thoughts on those, and how do you look at them?
So if it's an emergency, like a temporary restraining order, you need to call the clerks, say I have a emergency motion. When is good for the court to hear it? And it needs to follow the local rules. You need to give enough time to give notice to the other side. But then my clerk, in coordination with my coordinator, will find a time that works for me to fit it in. What doesn't work is showing up in my court and saying, well, I've given the other side 2 hours notice and we're here for an emergency hearing, because I'm in trial most weeks. And then if I'm not in trial, I've got hearings. And even on trial dates, I've got hearings scheduled even when I would take court breaks. So it really does help to call the clerk, say I have an emergency motion. When can the court hear it? When we have and there are some times that I'm slammed and I can't find a time, but I work with the other judges on the floor or other judges in the courthouse. If they can hear it because I'm stuck, we all try to help out in that manner.
So to accommodate those real time sensitive ones.
Yes.
So in actual like procedures of the hearings, I was actually at a event yesterday with Mac Taylor where several of the different judges were talking about some of their procedures. How do you like to get your information for a hearing? Do you want a binder? Do you prefer to have it all digitally? How do you like to digest stuff, especially for bigger hearings?
I think bigger hearings, I prefer written copies. So if they can be provided before the hearing, that helps. If it's just a 10-page motion or something small like that, digital is fine. I don't need anything else. But if there's case law that is really important or, a lot of exhibits, it just makes it easier for me to flip through if it's in paper. Now, I always say that, and then I had a bench trial a few weeks ago and I had about 6 binders, and I said, I'm rethinking my as I flipped through during the entire trial. I was rethinking
what have I done with my life?
why I didn't just use the zip file. But
Okay, okay. And then what are your thoughts? I know the district courts do have in the local rules some page limits. Is that something you adhere to, or just
I do not.
within?
I don't adhere to that local rule because number one, it wasn't passed by the Texas Supreme Court. It wasn't approved. So, and from my standpoint, it was just too broad because if you have to file a motion to compel and attach your discovery documents, which you have to, there's no way to be under that page limit. If it's a dispositive motion, you're attaching a contract, you're over the page limit. So for my court, to me, it just felt like I was giving myself more work on granting motions for leave to exceed the page limit. So
Makes sense.
don't operate under that.
And then kind of going into that, just into the actual, motions that you receive and information, are there any pointers that you want to give? Like when you see a motion, like, is there something like hallmarks that you're looking at this, like, this is going to be easy for me to digest, or, oh my God, how am I going to slog through this? Like,
I mean, well, there certainly is a difference.
yes.
In the first page or two, I can decide whether or not it's going to be something that's easy to get through or not. But I can't really give very many pointers other than the more that you can do to simplify it. And sometimes I've even thought recently on motions for summary judgment that maybe that means having more than one motion for summary judgment instead of having every ground that you're moving on in one motion, that it may make sense to have more than one. Because, I mean, looking at a 1,000 pages worth of motion and exhibits that's just difficult. So if you can break it down to simplify it, and of course, your summary of your arguments, I think it's always a good idea to give it to another attorney in your office and say, hey, can you read this? Does it make sense? Because it should make sense to anybody who reads it.
Yeah.
Otherwise, it's not going to.
Do you like PowerPoints for presentations? I know you've got the nice AV equipment now.
I do. I think they're helpful. I mean, I think sometimes they can be more effective than others. I don't particularly care for fun pictures or things. And that kind of goes back to professionalism. I think sometimes that can detract, especially in front of a jury, more than add to your arguments. But it certainly can simplify things and helps the court. And I think it helps more so in how you're talking about an emotion, simplifying things for the attorneys. Because if you have to go through your 15-page motion and put it all on just a few pages of bullet points, it can really help you in your mind simplify what your arguments are, which then conveys it easier to the judge.
Okay. Kind of switch gears a little bit. When is it appropriate in your court to ask for an associate judge? Or do you find that need very often in your court?
Well, right now I don't have an associate judge.
Oh, you don't? Okay.
A request wouldn't get you anywhere right now.
I guess it maybe a visiting, you might some of the visiting or.
So I have one, I have Judge Murphy visiting for me she essentially is filling a small role, a small part of an associate judge's role for me now on an ongoing basis until we have an associate judge for this court. So she hears, motions to appoint receivers, motions to, for default judgment, motions to withdraw on a submission docket on Fridays. So she just reviews them every Friday at 8 or 9 in the morning. But so other than that, typically when I do have an associate judge, I have a category of items that are going to be sent to that referred to the associate judge. And so right now, while I don't have one, I don't have that list for you because it has changed over the years, depending on the associate judge that I had and the time that they can give the court. But I am always assuming that I am confident in the associate judge's ability, which I suspect anyone we hire, I will be. I believe that an associate judge is an important part of the court system, coming from the family court where we had our own, and they very much did a lot for the court, and I relied on the associate judge. That's my intent once we do have one, is to use them as much as I can. I think it helps, especially on a lot of motions that, such as discovery motions, that I think a lot of times attorneys, they really just need that hearing to set it. Most of the time it's going to get resolved before the hearing actually comes. But then they don't necessarily need me to make that decision.
So I'm going to trail off. Just I'm interested. Like, what did you what have you found about the dynamics between having been on the family court and being on the district court? What are some of the things that you've seen differences, and is it a zoo in the family court?
I would not call it a zoo. I think you're very busy, and there are a lot of individuals who represent themselves, which comes with a unique, it's just a unique situation for all of them. But I always say the difference between family court and civil court for me is that in family court, you get a one-page motion and the attorneys are like, we need 8 hours for our hearing. And in civil court, you've got 5,000 pages on, motions and exhibits, and they're like, oh, we need 15 minutes. So it's different in that aspect. But I've enjoyed both, and I see the benefit. And sometimes as a family judge, you can feel like you're doing a little bit more for society and trying to help the people that are in the courtroom. But it does carry its unique emotional damage along with
I can imagine.
for everyone. And so you're dealing with that, for your staff, for yourself, and then of course for the parties, and then for the children involved.
So in general, do you have any kind of philosophies of, how you want your parties to, when they're engaging in discovery issues? Like, what are your general thoughts? What do you want to happen before they end up in your courtroom?
I want them to read the rules. I expect you to understand the rules related to discovery. Then I expect you to have made objections according to the rules, and then take reasonable positions based on the facts and the law. I don't like to see unreasonable positions of, extreme requests, just like I don't like to see extreme objections. So it works both ways. In my court, I'm not going to come in and rewrite all of your, requests for production because they're overbroad, because that's wasting my time. But I'm also not going to sit here and listen to, well, I made these objections just in case, judge, when in reality, it's not something that's in play. I think there's a lot of trying to protect yourself. And then I get litigants in the courtroom and they say, well, this doesn't even matter. We don't have this issue. Okay, well, then just say that. It's much easier to say that and then not end up here in the courtroom. And so I think reasonableness is what I expect from all parties.
With that, in the actual procedure in a motion to compel, I'm assuming you probably like your orders separated out so you can rule individually on each of them.
Yes, I think you have to remember, and I think this just comes along with the job. I didn't have any idea, quite frankly, coming into being a judge, what it was actually like to be up here. And we have so many cases and we hear so many things. Even when we're not in the courtroom, we're thinking about them. So it goes along with whatever you can do to simplify the process for us. It's going to be more successful for you and then for us in general. So a very detailed proposed order that sets forth whether it's overruled, sustained, or modified. And going by the particular line items that you're requesting is really helpful. It just works for everybody.
Okay. What, just kind of to tie it up, what are some red flags to you that someone's maybe abusing the discovery process? And, that, so someone's being doing some mischief with the discovery.
I think repeat offenses is the biggest red flag. If you're in here one time on a motion to compel and you have a reasonable argument, they lodge this objection and they won't tell me whether or not there's anything else there. So I need you to remove this objection because they won't voluntarily. That's reasonable. If there's, 12 motions to compel that have been filed over, 3 or 4 years, and the response is always something elusive, those are the biggest red flags for me.
Yeah, I've found that for us, probably the biggest cases we've had has been when they just refuse. And eventually the judge gets so fed up, they're like, okay, well, let's grant this motion for contempt now because you clearly won't listen to the judge, the court's instructions.
Yeah. And I think, you come into this and you kind of think there probably aren't very many Perry Mason moments that have happened. And everybody gets worried about discovery. But I've seen them. The Perry Mason moments on discovery have happened in my court in trial, that has just been a bomb going off. So I do think it's important. It's not something that I particularly enjoy presiding over, but I see the necessity of it and how important it is in the process. So I think, having an objection, even if you're wrong and I overrule it, but having an objection that's a reasonable objection that you just need the court to rule on is something different than, making a million unreasonable objections that you can't even justify to me when you're making the argument in court. That then makes me start thinking, well, there's something that you're trying to hide, which I know is what the other side is thinking. And so then nobody trusts the process because the other side and the litigants are thinking, well, what are they trying to hide? So I think it's easier and of course, I think everybody would agree that it would be easier if we can all be reasonable and then we can trust the process a little bit more.
Okay. I want to get some nuts and bolts of how you kind of conduct your trials. How long do you give parties generally for voir dire, openings, closings, and that sort of stuff?
So my standard, what I start with for voir dire is 20 minutes aside, but I ask what you are requesting. And if you request more than that, then I ask to understand why. Sometimes I can understand why because I know the facts in the case, but sometimes it could even be a simple case where it's typically not going to need more time than that, but there may be hot button items. If you've got a car accident and you've got alcohol involved or drugs involved, there are certain things that it's going to take more time to ask those questions with the jury. Then I always consider that request for more time. So I would say, 20 is what I start with, and it may end up probably being more cases get 20, but definitely I move away from that quite frequently.
How about for openings?
I typically ask each side how much they're requesting for openings, and unless it is totally unreasonable, I allow you what you request. I've only had a few cases that I felt it was unreasonable, especially because what you have to realize is I see it every day. So I know too what the jury, sometimes I say, let me help you. Because if they're zoning out and they're getting irritated with you because you're taking so long, that's not helping your client. And so sometimes it's not about me just being difficult and wanting to control the process as much as it is trying to make it a successful event to get a resolution for the parties. So I've only had a few times too where I've forgotten to ask and I didn't give a time limit, and then I really regretted that choice. So for the most part, I feel like attorneys are respectful of that and of the jury's time.
Okay. And lastly, how about closing?
It goes the same for
Same.
me. Ask what you're requesting. Sometimes I'm a little bit more limited on that, depending on what we've been going through in the trial. If it is a case where it took longer than it should have taken, the issues are very clear, and all we need is a decision, and the attorneys have just really been hammering on the same stuff, and I feel confident that the jury has enough and has heard the arguments throughout the trial, then I try to keep that a little bit shorter for them. But I do understand there are some cases that require more time. I will say, and this kind of goes back to one of your first questions, is a pet peeve that I have, and what I think is not effective in the courtroom is pre-admitting a number of exhibits, not asking a single question of a witness about those exhibits, and then wanting, a long closing argument as the attorney to put that together for the jury. And in fact, in bench trials, I've started saying that I refuse to do pre-admission of exhibits, because what I find is you want to admit 300 exhibits to be sure that it's all there in the record, but then me make a ruling after just seeing, the 20 or so that you showed. And it goes the same for a jury, is if that evidence is relevant, then you should ask a question about it from a witness or discuss it during the evidence portion of trial. It shouldn't be saved for closing. I think that's ineffective.
That makes sense. Maybe drilling a little bit into some of the plaintiff's practice. Probably with medical exhibits, I know that they're a little bit more, there's like little pieces of them that you'll point to, but sometimes there's kind of a bit of a stack of those. Is that a little bit more reasonable in that universe sometimes?
That is more reasonable, but I would also say is if you're only going to show 5 pages, do you think that the jury is going to go back and read 200 while they're deliberating? Because you don't have to introduce the entire record. You can just introduce the pages that are pertinent that you want to focus on.
Yeah.
So I do see that more frequently. And as long as something is mentioned, I have heard that, well, these are the few pages that we've showed you, but you have all the records back there if you want to go back and look at them. That's not as big of a deal to me as just not referencing it at all.
Yeah. Okay. That makes perfect sense. Well, okay. Well, I really appreciate this. So just lastly, is there any just kind of court specific things that you can think of that you'd like to share?
Off the top of my head, I don't know. I feel like we are definitely back to operating post-COVID in a manner that we're trying to do our best here to play catch up. I don't know if anyone has shared, but we have been tracking, and we do recognize that there is a significant increase in filings for all the district courts in Dallas County. So when you're thinking about time to get a hearing or time to get to trial, or the court's queue, it taking longer for you to get an order signed, we do have a significant caseload, as well as an increase in filings, as well as not having at least one associate judge right now. So I think we're all doing our best. So we would just ask for that understanding from the bar too, that sometimes it's easy to think, well, why hasn't the judge ruled on this motion? Well, I've got 1,300 pending cases, and and sometimes that can be more difficult than we all would hope that we can do for you. But we are trying our best.
So that is something that I actually haven't asked the judge yet, and I've always wondered, and I just haven't thought to ask. Is there a appropriate or polite way to, especially if an order is starting to get pretty long in the tooth, you're getting weeks, month plus out, what's a polite way to try to maybe get that back in front of the court's eyes?
Well, I think every judge is going to have a different measure of what's polite to them.
Yeah.
So I will preface it by saying that I have absolutely no problem with a polite request to my coordinator through email or through a letter that says, this was under advisement or we're waiting on this ruling. Because sometimes things fall through the cracks. I'm not going to say that doesn't happen. Sometimes something should be put on the under advisement list and it gets left off. And then if someone doesn't bring it to our attention, that's difficult. So I never feel upset or irritated when someone brings that to my attention that there's a ruling that needs to be made. Certainly the way in which you do it could offend me.
Yeah.
But assuming that it's polite and just a request, I don't have any problem. And in fact, I appreciate that because I don't want to miss things for people. So I think that's reasonable to do.
Okay. And the last question I have, what are some practice tips you would recommend for young lawyers in your court?
I think it's really important that young lawyers, if you can, come and watch proceedings. And I think a lot of attorneys probably operate on billable hours, and that's something that's difficult, right? I have been there, done that every minute you spend not billing is a minute you're going to have to make up somewhere else. So that's really difficult. So I would encourage older attorneys to give your young attorneys billable hour credit for attending hearings. If you want to make sure that they do it, figure out a way to monitor them. But it's so important to get in the courtroom. I have learned so much since being on the bench, just from watching what happens, hearing the arguments. I know for me, just voir dire was something that, coming out of law school and then being a civil litigator, you don't, in family law as well, jury trials just aren't something that you get very much experience with unless you're in a certain type of law firm. And so that process for me was very scary, thinking about it, having to do it for the first time. Well, if you come up here and you've watched it happen 5 times, I can tell you that you're not going to be as nervous. And so that to me is invaluable. If you can find someone that's willing to mentor you. As a young lawyer myself, I was very blessed to find attorneys who I trusted in their experience and their knowledge, and who were open to having a collaborative discussion with me about pretty much anything. I didn't ever feel like I was in a position in my career where I couldn't ask a question that I thought, even was a stupid question. So if you can find people like that in your firm, in your life, even if you're solo, if there's someone that you can reach out to as a mentor, there are a lot of great programs. And then just do as much as you can to try to not be as isolated, doing one motion or one topic or just focusing on one area of the law. If you can get into the courtroom, hear other areas, talk to other attorneys, I think that that's a really important process to go through as a young attorney.
Yeah, none of us are an island. It's going and seeing and feeling and watching, and that's the sauce. Well, Judge, I really appreciate you taking the time out today, and I appreciate you, and thank you so much.
Thank you. I appreciate you.
All right.
Have a good week.
All right, you too.